Good afternoon, dear students, alumni, and guests. My name is Professor Grażyna Rempielak, and on behalf of the Warsaw University of Technology Business School, I warmly welcome you to today's inspirational lecture. I want to welcome students and alumni of our university, Warsaw University of Technology, and in particular from our school, our partners, our guests, from the University of Salford in Manchester, Sheffield Hallam University, Baltic Management Institute in Vilnius and in Brussels, Goa Management Institute in India, HEC in Paris, the Management Center in Innsbruck, Polimi Graduate School of Management, Politecnico di Milano, Zicklin School of Business, Baruch College, New York City University, and the University of Minho in Portugal. Today, the inspirational lecture will be delivered by Dr. Jonathan Lord, who is representing Salford Business School from the University of Salford in Manchester. Jonathan is a senior lecturer in human resource management and postgraduate research director at Salford Business School, Manchester. Jonathan has previously been an HR director, manager, and consultant, working across all three sectors. Specifically working within the transport and construction industries, as well as carrying out HR projects within the public and voluntary sectors. His specialist research area is labor law, focusing on how it is governed and how workers' protection has developed over many centuries. He has researched extensively around employment tribunals and their importance within the employment relationship, and is host of the We Can Work It Out podcast. The topic he's delivering today is UK and EU labour law, divergence, continuity, and worker protection. Before we start, I would like to take this opportunity to invite you to the next inspirational lecture, which will be delivered on 12th of March by Ms. Sandra Bichl, who will be representing our school, with the topic Leveraging AI and Technology in Your Job Research. Okay, and now I want to wish you a good time with Dr. Jonathan Lord. After the lecture, you will be invited to ask questions on chat. So, Jonathan, you are more than welcome to start your lecture. Enjoy.
Thank you, Grażyna, and it's great to see you again. Grażyna and I used to work together at University of Salford, so it's always great to see Grażyna. We actually visited Warsaw Business School 6 or 7 years ago. We took the MBA students there, so we have a really strong relationship with the school. So, good afternoon, everybody. My name is Dr. Jonathan Lord, like Grażyna introduced me very warmly. So I'm a senior lecturer in human resource management at Salford Business School. And today I'm going to talk about labour law, and we're going to compare the UK to EU from the perspective of how you would handle dealing with different labour codes and different labour laws if you practice or have to practice across different borders, in particular the UK and the EU. Because obviously the UK is no longer a member of the European Union. We had a vote in 2016 and we officially came out of the European Union in 2020. So there are some similarities, but there are some divergences as well. And it's important to note what those differences are and what those similarities are and how you would then handle them in the workplace. So this is what I'm going to be covering over this lecture series. We're going to look at Brexit in terms of the UK and how it impacted the UK and the EU as well. We're going to look at a compliance calendar and what some of the reforms in the UK have been since Brexit, and obviously what has happened in the EU as well, because there have been some differences. So we'll look at the kind of overlap and what the divergence and differences are. Then we look at what that means actually in practice in terms of how you would handle possibly disputes, enforcement, recruitment and selection, and HR operations across multinational groups. We're then going to focus on P&O ferries, who operate worldwide. They're owned by DP World, but I call it the P&O sacking scandal of 2022, where 786 seafarers were dismissed without following proper labour processes, and it affected not only UK workers but workers outside of the UK and in the European Union as well. And I compare what happened with P&O ferries to what might have happened in the European Union and the different perspectives on enforcement and repercussions for what P&O did as well. And then we have a quick look at what happens in 2027 from a UK and EU perspective. So what are the legal mechanisms then for the EU member states, for the UK, and what similarities and differences are there? So with the European Union has always kind of set directives, a minimum standard, and then the member state would then go away and implement it from a national perspective. And a really good example of this would be around the Working Time Directive, which has been around since the 1990s. So the European Union insisted or directed that the member states had to have a maximum working week. They didn't dictate what that maximum working week would be. In the UK, we adopted a 40-hour maximum working week. In other EU member states, it was lower. I think the UK was one of the highest working weeks that was actually implemented. So the EU would drive a directive to have minimum standards, but they don't kind of dictate what those minimum standards are in terms of the actual hours or the pay or the actual detail of the directive. They allow the member state to do that. So the UK still has those EU-derived rules. There was a discussion about removing those EU-derived rules, but they were too far embedded into the law and too far embedded into working practices for it to be removed. There was going to be something called the bonfire of a labour law a few years ago in the UK, where they were going to remove all the EU-derived rules. And after a considerable amount of time and energy and cost to the UK government to try and pick out those laws, it was just decided to only only remove a few of the laws. So you can see how far the law has been embedded into all the EU member states. Now it would be very, very difficult for any member state really to remove a considerable portion of the EU-derived rules. The European Court of Justice, as I call it, the UK is no longer a participant of that. They're still a member of the European Court of Human Rights, but that's a separate body which was set up after the Second World War. The European Court of Justice is separate, and we're no longer subject to that. We're just subject to the UK courts, right up until the Supreme Court, which is the top court in the UK for cases that would go in that direction. Enforcement in the EU is mainly through labour inspectorates and some courts, but there is a stronger, I would argue, worker representation in many states. And you'll see some of those practices, co-determination, for example, and work councils are very prevalent in the EU, whereas in the UK it isn't. In the UK, we've got a high reliance on employment tribunals, and I research employment tribunals a lot in the UK, and they are absolutely swamped with cases. The backlog for some cases 3 or 4 years for really complex cases. So they're really reliant on kind of retrospective justice, if you like. But the UK has retained this EU derivative on labour law. They still have that embedded into the main echelons of labour law. The UK has updated the labour law though recently, so the Employment Relations Act of 2025 is probably the biggest labour law we've seen in the UK since the 1970s. So it has updated its labour law, which has been derived from the government that's currently in place. The EU has updated their directives, particularly around pay transparency and platform workers as well, whereas the UK haven't gone as far as the EU has done around pay transparency and platform work. So what are the overlapping areas within across the UK and the EU? So there is a core discrimination concept that is at the heart of, I would argue, all European Union member states and the UK. So in the UK, we have the the Equality Act, 2010, which is very similar to what you see across the European Union. You have 9 protected characteristics in the UK. So you are protected based on your age, your sexual orientation, your gender, your religion or belief, your gender reassignment. There are 9 protected characteristics where you are protected in terms of discrimination, and that's very similar to what happens across the European Union. There are minimum pay standards. Again, that came from the EU. The national minimum wage came in 1998 in the UK, which was a European Union directive. There's also things around information and consultation when you're restructuring and considering redundancies. That's very, very similar. So there are some overlapping areas of law. Where there is differences, though, there are differences around TUPE, which is Transfer of Undertaking Protection of Employment consultations. So when one company buys another company, or when a company buys a department or an economic entity from another organisation, there are differences in the TUPE regulations. TUPE again was a directive from the European Union, but it's gone in separate ways in terms of the consultation. So there are new directives coming in from the EU, like I mentioned, around platform workers and pay transparency. So there are set ways that you would look at an employment status. Within the EU, you would take it for granted that someone would have a certain employment status, whereas the UK would have to go to an employment tribunal to determine their employment status. Whereas in the EU, it is presumed somebody would be of a certain employment status. The UK is very litigant focused, like I've mentioned. We have many employment law courts operating. And in the EU, you have this social dialogue intensity. So social dialogue is about workers' voice, about works councils, co-determination, where you have to have a member of staff on the board of the company in many European countries. So there is clear overlapping, but there is also clear differences between the EU and the UK. Again, just drilling down into some of the specific areas, just so you can see exactly what the differences are and what the similarities are. This was a European Union directive around holiday or rest breaks. So you had to implement a minimum rest break within your member state, and then it was down to the national government to decide what that minimum break and rest break was, and holiday entitlement was as well. In the EU at the time, it was 4 weeks paid annual leave, which was the minimum standard, and then the member states could increase or stay at that level. In the UK, we have 5.6 weeks as a statutory leave, but we do have 8 what we call statutory holidays, sometimes colloquially called bank holidays. So we have 8 separate days a year, which cover religious holidays mainly, that companies can allow people to take off paid as well, which is why you've probably got that slight increase. But that's one of the differences. Again, you've got these minimum standards that are expected in the European Union, and it's down to the member state then to increase or to stay at that minimum standard. So implementation is variable, but in the UK, they are, I would say, fairly generous with holidays. In terms of holiday entitlement, Holidays can be paid in terms of you book a holiday and then you take the day off, or they can be rolled up into your pay now as well. So people who work irregular hours, when they get paid, part of their payment will be to include holiday pay. So they take time off, they won't be paid for that time off. They've already been paid previously. So there are differences in terms of how you tackle things like that. Some people like that system, some people don't, and it has bounced back and forwards in the UK about whether that is an acceptable way to calculate those types of things. So let's look at one of the biggest areas of employment law that's hit the UK for over 50 years. This is a huge piece of legislation. So it's the Employment Rights Act 2025. And I'll run through what some of the changes are, and then hopefully you'll see what similarities there might be in your own countries, and the difficulties of it being introduced as well. So the Employment Rights Act brought in a raft of labour rights. So it was brought in by the Labour government, which is in power in the UK at the moment. It was part of their manifesto when they were elected nearly 2 years ago to introduce more employment rights, to update employment rights. In the UK, we've seen different working practices be adopted now because of the changing nature of the sectors and industries that we have in the UK. So we have a lot of peripatetic workers, 0 hours contracts, workers who work for companies like Uber and Deliveroo, who potentially are self-employed. So they're trying to bring in legislation which protects more and more workers. And in the UK, we have 3 employment statuses. We have someone who's an employee, which is your kind of traditional employee, has full employment rights. You have a worker who has some rights, but not full employment rights. And then you have the self-employed. So it's a bit like a strand. And on one side, you've got the employee. On the other side of the strand, you've got the self-employed. And in the middle, you have the worker. And then you have the difference in employment rights. So what this Employment Rights Bill Act has tried to do in the UK, it's trying to support more and more people, and it's trying to protect more people who are not classified as an employee. So some of the details that have been introduced has been an increase in the protective award if you're making redundancies, and that's really important because lots of companies have got around redundancy legislation. So when you make somebody redundant, you have to follow redundancy procedures and provide redundancy pay depending on the length of service. It's applicable in the EU as well. They brought in a raft of family legislation. So now you have day one paternity leave rights. You have unpaid parental leave rights from day one as well. So you don't have to work for the company for 6 months. One of the biggest changes, and I would say controversial changes, and if you work as a manager or if you work as a HR person in a company, this might scare you. And I think it is quite scary. So the UK has implemented something called the Fair Work Agency. Now, the Fair Work Agency is a body which monitors the implementation of employment rights. Now, the reason why it's controversial is because the Fair Work Agency can go pretty far in punishing businesses. And I use the word punishing not loosely. I think it's quite an important term to use. So the Fair Work Agency have powers to fine. They have powers to actually bring an employment tribunal claim, so an employment law claim against an employer, even if the employee or potential employee doesn't want to bring the claim. So it can be quite scary about how this will be enforced. And it's made businesses very, very nervous about how it will operate. So the Employment Rights Act, it's brought in a raft of legislation. They did try to bring in legislation where people were protected from day one in terms of unfair dismissal. So unfair dismissal, in the UK, you have to wait 2 years before you can claim unfair dismissal. It's now been reduced to 6 months work in time. Again, it's quite scary for employers because somebody can work for 6 months and then claim they've been unfairly dismissed. And it isn't an awful lot of time, to be honest with you, for employers and employees to get that relationship, that working relationship right. So it has scared a lot of employers. So the Employment Rights Act has been one of the biggest changes in the UK, and a lot of it, to be honest with you, has been derived from the European Union practices. So the UK is very good at looking what happens around the world and trying to introduce some of the good practices that happens around the European Union and trying to import it into UK law. So if you're operating from a global perspective, it is difficult having to operate in line with different laws. So it's important to have a clear audit trail, to have a clear audit trail of what you need to do if you operate in different regions or different countries, have different policies and procedures, and try and align the UK policies to EU operations if possible as well. Try and reduce fragmentation. A lot of multinational companies do that. As long as you meet the minimum standards in the country that you're operating, you can have a policy or a procedure which is compliant across all of the sectors and territories that you operate in. So you can have that as long as you meet the minimum standards, which is what a lot of organizations do. It helps the management of staff if you have that. This is one of the biggest areas of law which has become important for commentary over the last couple of years. I would argue mainly because of what's happened in some of the big cases to the Supreme Court in the UK. Some cases have gone to the European Court of Human Rights as well. So we've had cases like the Uber case where some of the Uber taxi drivers have requested to be classified as workers rather than being self-employed. So they wanted minimum rights around sick pay, holiday pay, minimum wages as well. And Uber have tried to defend their relationship by saying, well, they're not actually an employer. They are just a provider of a digital platform that people can use to work. So they're not actually directly employing the taxi drivers. It was found in that case that went to the Supreme Court in the UK that those Uber taxi drivers were actually workers. So they weren't self-employed, they were workers and should have minimum rights. It's the same with Deliveroo. If you've heard of Deliveroo, which is usually a food delivery service, again, the riders who deliver the food wanted to have employment status as well. But Deliveroo were very clever and they allowed the riders to substitute, which means they were allowed to say somebody else was going to cover their shift, which meant that they were not workers, but they were self-employed. So this is how the law has worked and hasn't worked in favour of workers' rights, but also protected organisations. If you compare that to the Platform Worker Directive, which the EU has passed and will come into fruition this year, there is that presumption that somebody is of a certain status. Again, there's this national implementation, but there is that presumption that there is an employment status already there, so they would be an employee. There's that presumption. Whereas in the UK, you have to kind of explain why you think you are of that employment status. There are rules around people being managed through algorithms, which I think is very frightening, personally. Not that I'm scared of technology, but I think the management of people through algorithms is dangerous. I think it's very, very dangerous. And I prefer that humanistic approach to management. But many companies are relying on algorithmic systems to manage people or to act as triggers for them to be managed in certain ways. And there are other issues around data protection and data access as well, which the Platform Worker Directive is trying to address. So in the UK, you've got litigation because that's where it's headed in terms of employment status. Whereas in the EU, you've got more regulatory compliance. You have to comply with the regulations. Whereas in the UK, you don't have to comply with many things, but if you don't act in a reasonable way, then potentially you could then be taken to an employment tribunal. Another area of law then which is similar and different are family rights and flexibility. I would argue in Northern Europe, the Scandinavian countries, you've got very, very generous family rights, which is fantastic. Family rights have always been, for the last couple of decades, very high on those countries' radar. So you're allowed a certain number of time off, either paid or unpaid. If you're a parent, or if you're a carer, you have a right to request flexible working if you're a parent or carer. And those are the minimum standards, and it differs per nationality. So again, the EU has set minimum standards for this, and the UK has adopted a similar thing as well. We have flexible working requests in the UK, which is now a day one right. So you're allowed to request flexible working from day one, and you have rights to unpaid leave if you're a carer. You have rights to parental leave if you're a parent as well. And they've extended things like redundancy protection periods for those people who are currently pregnant or on family leave as well. So you can see the EU has implements these minimum standards, and at the national level then introduce whatever standards they want, as long as they meet those national levels. But the UK still kind of follows the European Union, really. It still looks to it as I would probably say as a best practice partner. So how do things work differently? I've kind of mentioned this a little bit, but in the UK, I would definitely say it's tribunal driven. So in the UK, you've got employment tribunals where the employee, the claimant, would submit a claim to the employment tribunal. It would then go to the employment tribunal system to decide or adjudicate over the dispute. In the EU, you've got more of an inspectorate process, whereby they would look at whether you're enforcing the rules and regulations, and you'll potentially be fined. So you're more conforming to the regulation. So I would probably say companies are more likely to try and conform to it beforehand, whereas in the UK, you are punished if you break the law. That's probably where you could probably see it. And the remedies, so the remedies for whether somebody has a dispute or not. In the UK, I would probably say it's compensation focused, where the claimant, the employee or ex-employee, wants compensation for the way they've been treated. However, in the EU, it's slightly different. You'd have different ways of approaching it, where it will be reinstatement, more about reinstatement, and trying to make sure that things don't happen again as well. So you've got different ways of approaching the remedies as well. So this is a case study, and this is a case study that we've currently researched. And you can access what we've produced, which is a white paper, just a government paper that we've submitted to the government. And what we've done is we've reviewed what happened in this instance and produced a report. And you can access this on the hyperlink on the slides, because I'm sure you'll get copies of the slide. You can access this report on the hyperlink at the bottom of this slide. So some of you may know or may not know P&O Ferries. They're a big historically UK company, been around for 300 years nearly, operating in different guises, and they were struggling financially. And on the 17th of March 2022, P&O Ferries gathered all staff members who were working into rooms on the ships. If they weren't working, they were sent an email via video, and And everyone was shown this video, and it was video by one of the senior managers in the company, that they were being dismissed that day. And as of that time, that day, they were no longer an employee of P&O Ferries. So 786 seafarers were affected and sacked on the 17th of March. So on 17th of March, within 90 seconds, because that's how long the video lasted, they were sacked, no longer a staff member of P&O Ferries. There was no consultation, there was no notice period attached to the process. Those that were working were told to go to their quarters, their rooms where they actually lived, because some of them lived on the ships, take any belongings that they had, and to leave the ship immediately. And if they couldn't carry some of the belongings, it would be sent to them at a later stage. What subsequently happened is that those 786 seafarers were replaced. They were replaced by cheaper agency labour. Again, what we found out through the investigation is that these agency workers were actually in a hotel, ready and waiting to come onto the ships to work. So P&O Ferries argued that they were losing money, they were in trouble financially. The biggest cost of most employees is salaries, so they had to sack the 786 seafarers and they were replaced with cheaper agency labour. So it was a case of fire and replace. Fire and rehire as a concept which has been around for a while, but this was actually fire and replace. And the seafarers were obviously upset about this because there was no consultation, and because they were dismissed on the 17th of March, the trade unions couldn't do anything as well because they were no longer a staff member of P&O Ferries, so they could no longer represent them as if they were an employee of P&O Ferries, so they couldn't take industrial action, for example. The chief executive officer of P&O Ferries, a gentleman called Peter Hebblethwaite, admitted in a Parliament meeting, which is the British Parliament, in front of British MPs, that they broke the law and chose not to consult despite a statutory requirement to do so. So they actually admitted they broke the law. In the Houses of Parliament, in front of British MPs, the chief executive of P&O Ferries said, yes, we were unlawful and we unfairly dismissed those seafarers. So how did they get around this? How did they get around not being taken to an employment tribunal? Because that was the only option for the 786 seafarers. How did they get around it? Well, they provided settlement agreements. And again, there are minimum standards for redundancy in the UK, but they paid higher than the minimum standards. So they paid the seafarers some money, but to receive that money, which is higher than what they would ever have received, either in redundancy and more than likely an employment tribunal, they had to sign a settlement agreement which waived their rights to claim anything at a employment tribunal. So they waived their right to go to a tribunal. So it was a big scandal, and 786 seafarers lost their livelihoods. And it has now become a really defining UK employment law debate around how companies can circumnavigate redundancy law and legislation, how they don't have to consult, and can actually fire and replace employees. So what were the obligations of P&O? What were the statutory obligations that P&O circumnavigated? So they should have consulted with the staff members. In the UK, which again was or is similar to the EU, you have to consult with the staff members. If you're making more than 100 staff members redundant, you have to consult now for 45 days. It used to be 90 days, but it's now 45 days. So they didn't consult for those 45 days. They just sacked the staff members in one day. And that was the main laws that they broke. They didn't consult and they didn't therefore follow the right process. So if it would have gone to an employment tribunal, it more than likely would have looked like they have not followed the right procedure, and therefore it would be unfair dismissal. So they didn't follow it, and the way they got around it was this method of payment and signing the settlement agreements, which are effectively non-disclosure agreements where they're not allowed to discuss it as well. The fact that they've signed an agreement. And the other reason why they were able to do this, which again, this happens around the world in maritime, and it's where the maritime flag is registered. So a lot of maritime companies register in different countries that don't have strong or stringent employment rights. It's called the flags of convenience. So lots of P&O Ferries ships weren't registered in the UK. They're registered in other countries, which had nothing to do with their home countries, but they're registered in other territories and regions, mainly because they don't have to pay certain tax requirements, but also they don't have to conform to the labour regulations of the countries where they're operating. And P&O ferries operate a lot out of the UK. So the consequences were that they didn't follow the right process and they paid those seafarers some money and they had to sign a settlement agreement. The government responded initially by saying they would fine P&O ferries and they would prosecute them. And actually nothing happened. Nothing happened. They brought in new legislation to try and tighten protections, but it's very difficult to implement because the implementation was left to the ports. So rather than the government implementing the protections, it was left to other bodies to try and fine and protect those workers, and it was never going to work. So effectively, the government haven't done anything with P&O ferries. The other thing about P&O ferries is that they're owned by DP World. DP World are a multi-billion-pound corporation. So the argument that they were suffering financially has been diminished because DP World, their parent company, are so financially good at the moment that the argument is, well, they should have had some support. So what are the core requirements then around redundancy in the EU, which is then drip fed into the UK as well? So in the EU, you must consult with redundancies when they are contemplated. Again, in the UK, it's a bit more of a grey area, but in the EU, you have to consult with employees if redundancies are contemplated. It's not that they're going to happen, definitely, but it's whether they're contemplated. So you have to have meaningful consultation. And the meaningful consultation is there to try and come to some type of agreement where you would avoid compulsory redundancy. And you have to outline the details of the redundancies, what are in writing, what are the reasons for the potential redundancies, how many people are affected, how you're going to select people as well. And also you would guarantee that the redundancies wouldn't take effect until after a minimum statutory time. So again, it's very, very similar to the UK. The UK has adopted this. It's not as stringent as that, but they have effectively adopted the EU minimum base. So what's happened in terms of the UK and the EU after Brexit? So it's been 6 years now. It's been 10 years since the vote. So the vote was in 2016. It took 4 years for Brexit to happen because of the disputes in the UK about it. But it's been 6 years now. So what are the kind of sharing foundations and what's the shift between the two different entities? So the majority of the UK labour law actually originated from the EU. The UK joined the European Common Market in the early 1970s, which is the European Union effectively. And since the 1970s, there's been lots of individual employment law that the UK has adopted around discrimination, so sex discrimination, race discrimination, equal pay. And then as time has progressed, we've seen working time regulations, transfer of undertaking protection of employment, collective redundancies. The European Agency Worker Regulations as well has come into force. So we've seen lots of sharing foundations between the UK and EU because the EU were unbelievably fantastic in directing its member states in trying to provide minimum standards across its membership. And we did adopt decisions made by the European Court of Justice as well through case law. So the UK is no longer bound by the European Court of Justice. So the decisions that are made in the European Court of Justice in cases are no longer applicable in the UK. And we have this legislation now, which came in 3 years ago, which not only enforced or allowed the current EU directives to remain in the UK law book, it allowed the UK to make other different laws as well. But I would say the EU has been really proactive in trying to protect workers' rights. And the UK, even though it's not a member state anymore, it's still trying to adopt some of those minimum standards. And I think that the closer relationship the UK is now having with the EU around trade, I think the agreements will be if the UK wants to trade with the EU, you'll have to adopt the minimum standards, especially around labour relations. So what are the consequences then for those operating across borders and for international HR professionals? When you're looking at the UK, I would say you would have greater restructuring flexibility. You're allowed to kind of be more flexible when you want to either dismiss or make somebody redundant or change things. I would say it's more flexible. You have more processes and more bureaucracy to go through, I would probably argue, with the EU. You have to consult, you have to have sometimes works councils, co-determination, but you have a high level of litigation. And in the UK, for compensation, it's unlimited for discrimination claims. And there's also discussions around having unlimited compensation amounts from fair dismissal as well. So there is a potential high level risk attached to not performing properly when dealing with workers' rights. So you don't have that pre-decision institution involvement. You have a retrospective look at what happened and whether you behaved reasonably, and then usually the courts will decide whether you did or not. If you're operating in the EU, you have to consult. I would say consultation is essential. That's a big facet of the European Union. Just speak to people, social dialogue. It's important to do that. And have the workers participate in decision making. Let them have at least that transparent process for workers to understand what's happening. And it takes longer, I would say, to do things as well. You have to take time to plan things. So overall, I would probably say that in the UK, the risk attached to labour law is after you've made the decision. That's what happens. And when you make a decision in the UK, you have to look at what the consequences will be of your decision. What will be the worst case scenario? In the EU, you have to look at what do you have to do before you want to make a decision? What implementation and what regulations do you have to follow? So what remains common then? There is that core redundancy framework across the UK and the EU. We have the transfer of undertaking protection and employment regulations, which are very common as well and virtually the same. And I think that will probably stay the same because of the trading, the trading relationship we still have. The discrimination foundations, I would say, are a golden thread through the employment relationship in the UK and the EU. The UK and EU, has this really great understanding of discrimination and how it operates and how to try and eradicate it or minimize it. And there's lots of anti-discrimination legislation out there. And also because of the history of the European Union members, lots of industrial countries and industrial practices where there was long working hours in dangerous environments, we now have working time principles where you can only work a certain number of hours depending upon which sector or industry you're working. The differences are around the platform worker regulation. So that I would say you're more protected in the EU. In the UK, it would depend on your status and whether you would shift from one status to the next. But there is the Independent Workers Union of Great Britain, IWGB, which has been formed from people that are Uber drivers, for example, that are now trying to protect people. So you're seeing a bigger remix of stakeholders trying to protect people. But again, it's more retrospective rather than having to conform beforehand. Pay transparency. In the UK, the public sector has to be more transparent than the private and voluntary sector. Whereas the EU, if you have a certain number of employees, you have to have a clear pay transparency to try and minimize the gender pay gap or other pay gaps that are applicable as well. Consultation is a big thing in Europe, and the UK, it's kind of there, but some companies, like you've seen with the P&O case study, they haven't really conformed to it, and you are easily able to get around it if you have the money to pay employees. So the UK system, I would probably say overall, is flexible in terms of making decisions, which is good for business. Businesses want to act in a flexible manner. They have to do because of the nature of maybe the sector they're working in. But there is a high level of judicial process involved as well. The EU system is more about worker engagement, about employee voice, about the protection from institutions and structures within the workplace. So I wouldn't say either system is stronger. And when I've discussed this with other labour law commentators, a mixture of the law and trade unions and HR practices like employee engagement is the way forward. I think you need different facets to try and protect people now. You can't just have a legal system. You can't just have a system that's reliant on trade unions. You can't just have a system which is reliant upon modern HR practices. You need a mixture of protections which will help both the employer and the employee. Because remember, labour law is there to protect the employer as well. It's not just designed to protect the employee. Labour law should be there to provide a framework for employers to operate in and for employees to know how they should behave as well. Okay, well, I hope you found that illuminating and you found it relevant to whatever you're studying or whatever your work is. You've got a QR code there. You're going to subscribe to my Substack where I put most of my work. I have a podcast as well. We have the P&O podcast. We have one of the seafarers who is talking about what happened on that day in March 22, what happened to him and what the consequences were of their actions. And you can find other things that I talk about as well. So I'd like to open up to any questions if you have any questions. Thank you, Dorota. Thank you very much. It's very kind. And I'll send the slides to the business school and let them send those slides on as well. So you've got them. Okay. I don't think there's any questions then, but thank you for your time. Again, I hope you found it useful in some way. I'll send the slides over. I've got my contact details on there. If you'd like to contact me, you can more than welcome to contact me. And it'd be nice to have a discussion about whatever you want to talk about. So thank you very much.